Hello everyone, myself Aishwarya, a legal intern at Lexis and Company, and my today's topic is distinguish between void and voidable marriage. Marriage is the voluntary union of one man with one woman to exclusion of all the others. Satisfied by the solemnization of the marriage, the Hindu Marriage Act 1955 provides three types of marriage: valid marriage, void marriage, and voidable marriage. The distinguish between these three relates the pre-marriage of the pre-pendiments of the marriage, which are clearly entitled in section 5 of this act. Then, if we discussed about the vast difference between void and voidable marriage, then what is void marriage? As per section 5 of Hindu Marriage Act 1955, it includes essential conditions of a valid marriage. It contains such conditions which, if violated, shall result a void marriage. Section 11 of this act had considered following marriages to be void. First one is where at the time of a marriage any party is living husband and a wife, that is bigamous marriage, is void. Second is when the parties of the marriage falls with the spenda relationship, that is same blood. A person cannot marry in the same family, that is to a person from A 5 generation from parental side, B 3 generation from material side, C the parties were within the prohibited degree of relationship. This section 3 subsection G of the Hindu Marriage Act 1955 talks about the degree of prohibition relationship, that is as follows: three parties of the marriage came with the degree of prohibition relationship. Then there are some consequences of the void marriage, which are: parties have no status of husband and wife, no status of wife and husband. Second one is child of a void marriage are illegitimate. This subject to the provision of section 16 of Hindu Marriage Act 1955. Then third one is a void marriage does not give to a mutual rights and obligations. Now we talks about voidable marriage. A voidable marriage which can be amalgamated or avoided the options of one or both parties is known as voidable marriage. Section 12 of Hindu Marriage Act contains the relevant provisions of voidable marriage. According to it, in this case of marriage being voidable, the court may be declare it null under following conditions. First one is the material cohabitation has not occurred due to the impotency of the respondents. Second one is where at the time of the marriage any party failed to give the valid consent due to the unsoundness or has been affected by the mental to such extent that he is capable to marriage. He is incapable to marriage and giving the birth to the child, or suffer from the frequent insanity or insane. Then second last is where the consent of the guardian is necessary for the marriage. Such consent has been obtained by the force or by fraud as to nature, rituals, or any actual facts or circumstances as to be respondent. Then last one is where the respondent is pregnant at the time of marriage from a person other than the applicant. Thank you.